Hello, everybody. Assalamu alaikum, Sastikal, Namaskar to all the listeners. This is the Shah Peerally Law Show, and today we are going to have Attorney Sharif with me, I guess, and we are going to talk, of course, about immigration law, EB1, and national interest waiver. And thank you, Vidika, for being on the board with us today. And we will just jump in, but before I start, anything we're telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Of course, we will be taking few callers, but not right away. So right now I have Sharif with me. Sharif, hello? Hello?
Yes, Sharif.
Sharif, you're live on air. Can you hear me?
Great, I can hear you well. How are you doing, sir?
I'm doing well. And ladies and gentlemen, for those who don't know Sharif is an attorney working with us in our Washington office, and he handles all the cases, especially on EB1, L1 visa, national trust waiver. And many people have called him now the wizard of EB1 because of the kind of things he has done with the EB1, and I wanted to mention that. And Sharif, today we're going to talk a little bit more about national trust waiver, although we're going to cover, of course, EB1, O1, L1, etc. But I'm going to let you kind of start and talk a little bit about the national interest waiver we were talking about earlier. And for those who don't know, a national interest waiver is something that you can get. You don't need an employer to file for that. It's a green card, and you don't have to be an H-1B or anything. But the good news with the national interest waiver, although it's an EB2, you can still use that to get extension on your H-1B, or you can even, and plus you keep it with you. You don't have to keep applying every time you change job. So I'll let Sharif talk a little bit about that, and then Sharif, tell us a little bit what's going on in that area, because this is something big, and now the dates are back on our visa bulletin. So what's up? What's new?
Yeah, so Attorney Shah, thank you for the opportunity. I think what you just stated in terms of an introduction regarding a national interest waiver is probably the most relevant point that I wanted to share with our listeners, because if you are in a situation where you have a previously approved EB2 and you are on an H-1B, you are at the mercy of your employment status. Therefore, you are not really able to pursue, all of the opportunities that really exist in not just the U.S. Marketplace, but in the global marketplace as, a talented individual. So rather than rely solely on an employment-based EB2 situation, it is very, very wise and important for folks who are out there to consider having a national interest waiver approved, because really that national interest waiver is personal to you. It stays with you. If you, for example, have an I-140 national interest waiver approved in the EB2 category, and you happen to be, for example, from India, while that may not give you the ability to adjust status immediately, it certainly gives you an important benefit in having the ability to continuously renew an H-1B visa, for example. But I would argue, more importantly, it gives you independence from employers, such that if, for example, you wanted to take an opportunity in Europe, Australia, Singapore, Canada, India, wherever, you continue to have this I-140 approved, and will, at some point, hopefully, if Congress ever gets its act together, or if the dates become, current, can then rely on that national interest waiver, I-140 to, get a permanent residence in the United States. So again, I think a big qualitative difference between having a I-140 approved through an employer and having a self-petition national interest waiver in terms of benefit, the outcome of whatever process you undertake. You need to look at what is the benefit going to be. So now that we understand what the potential benefit of having the national interest waiver is, we could discuss a little bit about the process. if that's okay. Was that what you're looking for? Did you have any comments about that sort of
exactly.
thought process?
Yeah, we're going to go into that, but just wanted to encourage, because a lot of people, our clients, are from India, and they don't see the advantage of the national interest waiver because it's an EB2. The truth is that it has a lot of advantage. For one, as you know, if you jump from one company to another, so each company will have to start over to get your green card. But with the national interest waiver, since it is a self-petition, you carry that with you until your dates become current, and it gives the same kind of value for extension of H-1B, etc. So this is an interesting thing that people should consider. Of course,
exactly.
EB1 is the first option, but national interest waiver is a very interesting option. And if you are born in another country now, or your wife is born in another country than India, well, that is really basically the lotto, because then you can use that directly to get your green card without having to use a company. So go ahead, Sharif, tell us a little bit about the national interest waiver, how you can get it, and who can qualify for it.
Sure, I will. One last point, just on the kind of benefit of the national interest waiver and the positioning of it within the immigration, arsenal. So I think another point that we need to understand is that while the economy may be okay right now, those of us who have been in this country for in my case, my entire life, we have witnessed so many cycles, and there will come a cycle in the very near future where layoffs will happen, and those will impact even the most talented people. So rather than put yourself in a situation where you're working in a large software company or something like that, and you're susceptible to layoffs or situation like that, and then you're all of a sudden losing your immigration status, having to scramble around looking for a different employer and accepting something that is probably under your intelligence level, then have a backup. That's what this is about. This is about protecting your own interest. Because when you're in the situation that we're in, you really need to think about self-interest and preserving your self-interest. So that is what I like to always advise my clients. So regardless of your situation, I definitely encourage you to have a consultation so that you can assess whether or not this is something that would be a benefit to you. Now, getting into the substance of a national interest waiver, the first thing that we want to find out about whether you qualify is the holding of an advanced degree. So in order to qualify, it's like a prerequisite step for a national interest waiver, is you need to provide documentation like academic records, certificates, transcripts, and if it's a foreign degree, a U.S. Foreign equivalent, demonstrating that you have basically, a master's advanced degree, or at least a bachelor's degree, a baccalaureate degree, plus 5 years of work experience in your field. So those are the two possibilities. Either you have a bachelor's equivalent plus 5 years of work experience within your field, or you have an advanced degree, master's degree equivalency or higher. That is basically just the entry ticket, all right, in order to be considered for a national interest waiver. Now, once you look at the situation and have determined that you fall within a candidate for a national interest waiver, you need to demonstrate 3 basic requirements, okay? So the first requirement that you need to show, and I'm going to kind of bring it down to a more layman term so we can understand exactly what we need to present here. That is, number 1, you need to be working in an area that is naturally beneficial to the United States interest. This is what the law calls intrinsically beneficial, but you want to think about it as naturally important. So, for example, you could think about it as technological advancements that you're bringing forth. Certainly in the healthcare realm, that is definitely going to be something that national interest waiver will cover. A lot of our previous clients have been working in engineering, certainly whether it's resource engineering, such as petroleum, or mines or other natural resources. So those kinds of economic impacts are certainly areas where a national interest waiver will be considered, that you're working in an area that is beneficial. It's not about you personally at this point. The first requirement is the area that you're working in. We want to know that the area you're in is something that is beneficial to the United States. I think that for the most part, we can put folks who work in the IT space within areas that are naturally or intrinsically beneficial to the United States. A lot of it has to do with positioning them in their respective niche. So if, for example, they're in the IT space and are dealing with, let's say, data warehousing, for example, or data optimization, then that is something that we have to position. Why is it important for national interest? What is the key point here? How is this, collection and, of data and organization, a national interest situation, things along those lines. The second requirement of the three requirements for a national interest waiver is that you are personally well positioned to advance the interest that we discussed in the first criteria. So if the interest is going to be, for example, that you are protecting data warehousing of digital content, for example, that relates to private U.S. citizen or U.S. resident information. How are you well positioned to fulfill that interest? Okay, well, I have certain education qualifications. I graduated from a very high prestigious technology institute. I've been working for the most important, largest companies that deal in this kind of data protection industry for the last decade. I have created applications and processes that protect this information, things along those lines. So now I'm discussing my own personal worth with respect to how I will fulfill this area that is naturally beneficial to the United States. Okay? So the first requirement is, what is our area? What is the area of endeavor that we are working in? The second requirement is, how are we well positioned to advance that specific beneficial area that the U.S. is interested in having you pursue? And then the third requirement is what's called the balance test. So this balance test is best understood by us considering, what is the national interest waiver all about? Why is a national interest waiver called a national interest waiver? Because you are waiving the requirement of an employer sponsoring your immigration, I-140 immigration, and going through what's called the labor certification process, which we commonly refer to as PERM. So you are waiving the PERM requirement. Because you are waiving the PERM requirement, we need to do a balance test and determine whether the national interest of having you, who are well positioned to advance this natural beneficial area that we've described. For here, we talked about data warehousing, for example. Is the national interest of having the candidate or the applicant remain in the United States heavier or more weighty or worth more than the potential negative impact on U.S. citizen workers by having the applicant bypass the labor certification process? That is what the balance test is all about. Now, one way, and this is provided in the Danisar case, which is the legal case that really set the national interest waiver law, it talks about where, for example, the policy of the employer or the policy or the circumstances of potential employment do not allow for a perm application to be submitted. An example of that would be a person who may have interest from a public employer, such as the state of California. State of California, as a matter of policy, does not sponsor foreign workers. Therefore, a person who is well positioned to advance the interest of a work being done at the state of California may be very easily qualified for a national interest waiver, because they are not doing so in a way that is going to negatively impact U.S. workers. And there are many other arguments that we can make around this issue, but ultimately, to get, I guess, into the weeds a little bit, those are the three major things that you need to understand or overcome in order to be successful with the national interest waiver petition. Just to put it into context a little bit more, a lot of you have, heard our discussions in the past about EB1A and demonstrating, the statutory requirements for proving extraordinary ability. Proving eligibility for a national interest waiver is less rigorous, and I would say a much broader set of individuals will qualify for a national interest waiver than those who would qualify for a EB1A petition.
Indeed, that's where a lot of people are not aware of, is that the national interest waiver. However, one thing with the national interest waiver, which is kind of interesting, you have to meet the requirements of the EB2. That means either a master's degree or bachelor's, a 4-year bachelor's plus 5 years of experience. So that's, I wanted to add this footnote there. But Sharif, give us a little bit some of the examples of the kind of national interest waivers you have worked on, so that people get a better idea where they can get a national interest waiver and why they should get a national interest waiver.
Sure. I think that basically a lot of the national interest waiver candidates tend to come from folks who maybe came out of STEM, STEM fields, so science, technology, engineering, math. And those are certainly the easiest maybe areas of national interest waiver becomes applicable, but they're not exclusive or the only areas of qualification. So, I would say folks who are currently on, like PhD candidates or postdoc are generally well positioned for national interest waiver. Based on a lot of the research and, information. So I would say 30 or 40% of the cases, when I think about it, we're probably talking about PhD or postdoc people. But the vast majority of the cases, though, are going to be from people who are in industry, folks who have, worked along the lines of, physics, maybe doing different kinds of research within the private sector. We've also had people, certainly computer science backgrounds, biologists, people that work in drug research, I think design of applications, all of that I think has certainly been an area where we've been very successful. I think for what I'm looking to do here, though, is I think reach some of the people who aren't really thinking about national interest waiver and will end up prejudicing themselves or hurting themselves because they did not take the time, the effort, and to reach out and get professional advice about this alternative path. Because, what I'm really, really worried about when I look at the immigration landscape is that these folks may be abandoned by employers. So, I think the class of people that I'm really looking for in terms of national interest waiver are people with lots of experience who are maybe, kind of in a comfort zone with a particular employer, but don't necessarily consider that comfort level is a little bit, probably taken for granted, and where it should be, looked at a little bit more closely. Because, Shah, you know this better than I do. What happens in the event of layoff with a person that's on an H-1B, I-140 approved? And what even worse, I don't mean to scare people, but I just want to, I want people to be careful about their life choices. There's a lot riding on the line. What happens where there are not jobs that are, going to be replace those positions? And we're seeing this, I think, in different industries. So, for example, oil and gas has been very, very hot for the past, 10 years. But if you know anyone in the, kind of Gulf area, you'll know very well that people are losing jobs left and right. The entire industry is being, kind of wiped out in the oil and gas right now because of technology, because of different, pressures, because of, I think, long-term views on what kind of position that's going to be in. So all of a sudden, people that have been working on H-1B, EB-2 approved for, different oil and gas companies are starting to get pink slip. And not only that, but there's nobody in the industry that's hiring, or very few. Or you have to take a position that you don't feel necessarily comfortable with. While at the same time, there may be better opportunities elsewhere. However, you then have a choice to say, well, is my future in the U.S. no longer worth it? So, I think if we're looking at examples of who should be considering national interest waiver, I think it's very, very broad segment of, professional, highly skilled workers who want to basically, make sure that the status that they've earned over, many years of hard work does not go wasted.
Exactly, and this is where national interest waiver becomes interesting, because the fact that it follows you, doesn't matter where you're going, how you're going, you name it, but you basically going to be kind of keeping it if you move to another company or another job. And that becomes a major thing, because the problem that we are facing right now is a situation where we see a lot of people getting actually stuck because they just kind of are dependent so much on the company. So it is to their advantage to actually go for a national interest waiver if they have a chance to do it. So this is the interesting part of that. Anything to add on the national interest waiver, Sharif, and then we can talk a little bit about the other areas. Another things I wanted to discuss, we have not really discussed, are L1 visas and the EB1C. So anything else on the national interest waiver you want to discuss on?
I would just encourage people not necessarily to make any, I think, quick decision, but just to investigate whether this is something that may benefit you. And also consider that there may not be any downside to this. So if, for example, you are in a situation where you have an approved I-140 and you're on a H-1B that is being, continuously renewed based on your employment status, you may consider yourself to be in a comfortable situation or relatively comfortable situation However, we never really know what's going to happen with the employer, and the employers at the end of the day, as anyone that's worked in HR will know, nobody is indispensable. So they will not care much about your immigration status at the end of the day. Therefore, I strongly encourage folks who have anything to lose to reach out and talk to us about national interest waiver and allow us to look at your profile and determine whether this would be something that is beneficial to you. So that's basically all I have to say there.
Exactly, and that's important part to talk about. So for people who want to know more or want to do a consultation and assess their case, please give us a call, 510-742-5887. 510-742-5887. Today is September 26, 2019, and I have Attorney Sharif Silmi with me, and we are discussing about national interest waiver. For those who don't know, Sharif is a very good attorney. He's with us in Washington, and he handles all the cases when it comes to EB1, L1 visas, national interest waivers. So now we're going to talk a little bit about EB1C for people, because a lot of people don't even know EB1C is a green card that usually is attached to the L1 visa, but you don't have to be an L1 to file it. So Sharif, let's talk a little bit about EB1C, the requirements for those people who are executives and or in a managerial role, and then we can come back to EB1 after that.
Sure. So I think the thing that folks need to understand about the EB1C visa is that it's basically a classification for what is termed managers and executives. So multinational managers and or executives. So this allows a foreign company, right? So, for example, an individual is working in a managerial capacity or executive capacity for a foreign company, for a company that is not in the United States, to transfer that manager or executive to a related, and if we're talking about EB1C, existing U.S. company. So the U.S. company, it does not need to get like a labor certification to hire this worker. Instead, they can simply hire the foreign worker through a job offer, and as long as he has served at least, or she has served at least 1 year within the foreign company at the time of the application, and is, basically primarily in a managerial or executive capacity, and I could discuss more what that means, then that person may immigrate to the United States. So without kind of going on it's very similar to the L1A, as both classifications, require the immigrant or the foreign worker to come to the United States to work in a managerial or executive capacity. However, that you definitely need to know that the EB1C will be evaluated more strictly. And secondly, the EB1C will, you need to be established in the U.S. So with the L1A visa, not to confuse people, but you can actually come with a new office situation, with opening a new business. But with the EB1C, the U.S. business as well as the foreign business must both be established previously. So basically, and then the other point is just like most other visas, if you are able to be successful in getting an EB1C, then you can, it does benefit your spouse, benefits your children. And, I think ultimately the purpose is to allow the transfer of a manager or executive from the foreign company to the related U.S. company. So what this opens up then is a discussion of what is the relationship between the foreign company and the U.S. company. So those companies have to have a relationship, and there's basically three types of relationships that are considered qualifying according to these statutes. The first kind of relationship, and I think the most common one, is going to be that of a parent or subsidiary. So basically here you have a company that's based in the U.S. and has a foreign subsidiary, or you have a company that's based, for example, in Canada or Europe or India or anywhere else, and they've established a U.S. subsidiary. So either parent-subsidiary relationship, as long as that can exist then and can be demonstrated, then that will allow for the relationship of a intercompany transfer to occur. So basically what we're saying is this transfer is taking place within a umbrella of companies, right? So you have the executive or manager who's working at the overseas entity. They work for us, over 12 months. We are now transferring them to the United States to undertake some, performance, which is a continuation or an enhancement of his or her managerial or executive duties. So that's the parent-subsidiary example. The next example can be an affiliate relationship. So an affiliate relationship between these companies is a relationship where at least 51% of shared ownership exists among the organizations. So you don't have to have complete and total ownership like a parent subsidiary, but you have to demonstrate that a majority of the company is owned by the related organization that the individual worked for. And then a branch office is kind of similar to a subsidiary, where you've opened or have a branch office that relates back to the parent company. So, I could get into more detail in all this kind of situation of what the different types of parent-subsidiary relationships are, but I think for our listeners, what you want to know is that this EB1C avenue will only exist if you are presently working for a company overseas in a managerial or executive capacity, and that company has some kind of relationship with a U.S.-based company. And that U.S.-based company has existed prior to your intended immigration period. So,
and you have to be here for 1 year, right?
That is basically, in a nutshell, what we're looking to do with the EB1C situation. And again, I think the backlog of the State Department bulletin definitely makes this process a little bit difficult presently for people from India, and also there's a lesser backlog for people from other countries, but nonetheless, for people who do not want to go through a perm, sponsorship process, and you have an employer that is multinational with entity in the United States, then this really gives you a very good pathway to immigration to the United States. In fact, it's so successful that my theory is that this is what is causing the EB1 backlog. So
yes,
there you go.
I was going to mention that, but that's the part which is the most tricky, because it's unfortunately fortunately,
or it could be us getting people EB1As. I don't know, Shah. It could be one of the two.
Maybe that, because we're doing a lot of them, right? So now, I just wanted to mention again to all the listeners, anything we are telling you today is our opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And this is Attorney Shah, Peerally, and I have Attorney Sharif, Silmi with me. In discussion, we talk a little bit about the national interest waiver, and I know we're not taking any callers, but you can call next week. But this week we wanted to discuss about the national interest waiver, because a lot of people don't realize how good it is sometimes to have it. And now, Sharif, we talk about EB1C. Let's talk a little bit about your favorite, the one that made your name. So talk about the EB1A, the famous EB1A. What's going on now? And I know there are some issues going on in some service centers, and unfortunately, but at the same time, we're still getting approvals going strong. So tell us a little bit what's going on there.
Yeah, and we are fighting. I mean, I think that there has been just kind of to maintain transparency with our listeners. I've been kind of preaching this for a very long time, which is that the sustained acclaim criteria within EB1A. So just to give a brief overview for people that are not familiar, in order to be approved for an EB1A petition, you need to demonstrate 3 requirements. The first requirement is that you'll prospectively benefit the United States, that you're going to bring about future benefit to the U.S., more or less. The second requirement is the most, I think, relevant or important, is to demonstrate that you have already achieved sustained acclaim that is recognized in your field of endeavor. And we demonstrate sustained acclaim through meeting a minimum of 3 of 10 criteria. So, for example, you demonstrate that you perform in a critical role for an organization that has a distinguished reputation. You demonstrate that you command a high salary. You demonstrate that you have publications. You can demonstrate you have original contributions of major significance, awards, et cetera, et cetera, et cetera. So that is what sustained acclaim is all about, is those meeting a minimum of 3 of 10 criteria. And then the last requirement is that you continue to work in your field of endeavor. Most people tend to focus only on sustained acclaim, and that is to their peril. I've always argued that we need to take a more comprehensive approach that meets the statutory criteria, and I think there's very good reason for that. Some of the more challenging cases within the EB1A context have become postdoctoral researchers. And those are the cases that were, I would say, 3-4 years ago, considered the easiest within EB1A. And those have now become the hardest and the most heavily scrutinized, because the adjudicating officers are now looking at them and saying, look, your job is to publish material. Therefore, the fact that you've published material, while it meets the plain language meaning of the criteria and establishes that particular sustained acclaim criteria, it does not necessarily mean that you are a person of extraordinary ability or that you are recognized in your field. Because ultimately, the major test of EB1A is demonstrating recognition. So we have, without revealing too much, confidential information, presently, one case in our firm where the applicant actually met 4 criteria, not 3, but 4 criteria. And the adjudicating officer still denied the case. And we have looked at this, and there's a lot of, I would argue, deficiencies in the reasoning of the adjudicating officer, and we're currently going to, appealing this case. And I want people to understand that the fight never ends for us, really. I mean, we have to pursue these cases all the way through, and it's not just for the sake of our particular client, but it's for the sake of every person that comes after them. Because where, for example, you have shown recognition within these criteria, and not only meeting 3, but meeting 4 of the criteria, and those criteria are objective and have demonstrated that you're recognized in the field, they should establish the overall extraordinary ability. But I think what this does as well is gives us another opportunity and learning lesson that, we've known for a very, very long time, but some people don't necessarily, internalize or accept from us that the criteria alone will not suffice. The other point I would make is letters are not the be-all and end-all of an EB1A case. Every immigration attorney that takes EB1A cases in this country seems to think that letters are the most important component of an EB1A petition, I would argue that is not the case.
That's important.
I would actually...
Yeah, exactly, because a lot of people, what happened is that everybody now research online, but the approach we have taken and you have taken is so different that sometimes they get lost what we are doing. However, they have to go to the source of what is an EB1. And tell us a little bit more about that, because it is important that people understand that just because another lawyer told them, hey, they don't qualify, it doesn't mean they don't. Because I've seen a lot of people they could have already been a green card holder by now, but the lawyer told them, oh, go and get this extra, get this extra. I'm not saying not all the time they're wrong, but many times they are wrong, and those people lose their chances. So give us a call at least. Let us do an
it's very, very sad. I think I think one fallacy or misunderstanding within the context of EB1A is that you have people who work in areas who are highly skilled, highly talented, make a lot of money, have a claim, are wonderful, wonderful people who work in areas, and then they go to an attorney or just maybe they're doing online search and trying to figure it out for themselves. Or I think the most common misinformation will come from within their company, and they will tell them, oh, I know, they'll, for example, be working as a maybe senior, product designer, right? And the company, will tell them, EB1A is not for you because you don't have publication. That is the stupidest advice that anyone can get. Because can we just think for a moment? Why would a person who creates products, beautiful, useful, amazing products that make human life easier, better, etc., write articles and publish them? They don't do that. People who make products don't publish articles. So why are you telling this person, I'm sorry, you should go spend 2 years publishing articles, when you're 37 years old, 42 years old, and you've never published anything in your life? It makes no sense.
It makes
you
sense
need to prove sustained claim.
Right?
The number one thing I see, mistake that I see, is that people have a tendency to create or solicit evidence for the sake of filing their EB1A petition. That is not the soundest approach. My approach, my very, 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 thank God, successful approach, is that we look at the entirety of your career and we extract the evidence from the entire career span. And if you're only focusing on the 3 months, 4 months before you submit your petition, you are bound to fail. You will fail. I'll bet $1 to a donut that you will fail.
Yes, and I've experienced this myself, because I used to take the same approach for clients until you came in the picture and changed the whole thing. But the truth is that many people are just following, and then they, of course, another thing that is kind of the little bit heartbreaking more is you see people kind of listening to those lawyers, and they get, although the lawyers personally they think they're doing the right thing, they lose all those chances. And since the date were current, they could have already gotten a green card by that now, and even maybe be eligible for citizenship. So don't lose time on this. Let us assess your case.
Absolutely.
Give us a call. 510-742-5887. Give me 1 second, Sharif. I think we have 5 more minutes to go, so I'll let you conclude on that. But go ahead.
Sure. I just want to kind of talk about this issue of taking advice from your company, particularly your company attorney. So, just so you understand the rules of professional responsibility for attorneys, if I am employed and paid by a company, right? Let's say we'll just call it, Acme Software Engineers, and Acme pays me beautiful money to protect Acme. So if an Acme employee comes to me as Acme's attorney and asks me something, anything, whatever it is, I will answer that person according to what is in Acme's interest, not according to what is in, the employee's interest. Okay? You need to be very, very careful who you get your advice from. If you call Shah and make an appointment with him and speak with him on the phone, and you happen to work for Acme, he doesn't give a damn about Acme. He only cares about you. I only care about you. We don't care about your company. We care about you. If your company hires us for a particular situation and, it's not a conflict of interest or whatever else, then sure, we will look after that company's interest. Maybe it's a O1 visa, maybe it's a H1B, maybe it's a lot of things. But in the case of a self-petition, if you are going to your company for advice, you are making an enormous mistake. So I'll just conclude with that.
Okay, that's very, very important. I don't know how much time we're left, Vidika, so let me know. But I just wanted to recap quickly and tell people today we have Attorney Sharif, who actually took some time and was able to join us today for the show. I wanted to thank him a lot. And for those who are new to our show, our law firm have been practicing immigration law now going on almost 15 years, and we have been pretty good at that. And now I was talking to Sharif, who's really kind of now the point of reference when it comes to EB1. I think Sharif, at this point, I think you should start writing books on that. So there are so many things that we didn't even know. I myself been practicing for a long time. I was not looking at it from this perspective until Sharif came into play. But let us check your case. If you want to know more, just give us a call, 510-742-5887. 510-742-5887. We don't do only EB1, by the way. We do EB2, EB3, you name it. Family petitions, H4 EAD. As you know, we have fought a lot for the H4 EAD. So if you need help, feel free to reach out to us. We also handle debt settlement. For those who don't know, if you have problems with your credit cards and things like that, and you are in California, feel free to give us a call, 510-742-5887. The website to check, attorneyonair.com, attorneyonair.com. So Sharif, we have two and a half or 3 more minutes to go. So any conclusion on, let's talk quickly about O1, because you have to recap it in 2 minutes. So tell us a little bit about O1.
Sure. I think the point I would take from O1 is that if you want to get away from the H1B situation, or if you're, for example, in a STEM OPT and you're not getting your H1 picked up, that's a great conversation to have with an employer. And if you are a startup and you want to acquire talent, right, I would say O1 is the way to go, because you still, basically have the exclusive right of employment with the individual who you will sponsor. However, you are not limited by the H-1B cap. So if, for example, I'm, starting a IT business and I want some very, top-notch talent from IIT in India, then I don't even need to focus on people in the United States. My company can just find the right candidates recruiting from overseas, and if the person, is IIT material and they have, met certain qualifications, then an O1 is an excellent way to go forward. I've gone, looked at situations where people with O1, and, you'd be surprised who could be approved there. So the requirements are less scrutinized than the EB1A, but they have similar or overlapping, requirements, because both are for extraordinary ability. The difference is the O1A is a non-immigrant visa for individuals with extraordinary ability, whereas the EB1A is an immigrant visa for individuals with extraordinary ability. And also, someone who goes through the O1A process is certainly going to put themselves in a situation where they can definitely continue to build their profile such that it may be put forward as an EB1A at some point in time.
Beautiful, beautiful. Thank you so much, Sharif. And we'll be back next week. And I just wanted to thank you again for those who just who didn't have a chance to listen to the show. We are going to republish this show hopefully on our YouTube channel, youtube.com/Peerally. So please subscribe. There are a lot of information there. You can also listen to our old shows. And I wanted to thank Vidika for being on the show with me. Thank you, Sharif, and we'll be back next week. And before I close, I wanted to mention again that we also help with everything on immigration, family petitions, marriage petitions, H-1B, L-1, H-4. So you name it, we can help you. So just give us a call, 510-742-5887. The website to check, attorneyonair.com, attorneyonair.com. And also, if you need any help with debt settlement, feel free to reach out. The website to check is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. What the debt settlement is basically getting out of debts without having to file bankruptcy. It's a different department. We just help people on the side on this. So please give us a call if you need help on those. So I wanted to thank you all for listening. We'll be back next week, same time, with another show. And again, if you want to listen to the show, it will be on our YouTube channel in a few days. So please check it out and subscribe to the channel. Shah Peerally Law, Shah Peerally Law, my full name, SHAHPEERALLYLAW. Thank you. Take care. Bye-bye. We'll be back next week.
Thanks, Shah.